All right, today we are going to talk about dispute settlement, some issues with regard to international law and dispute settlement, and expropriation, and some of the different issues involved with that. So I want to begin on this slide here. We talk about dispute settlement in the realm of international law. Of course, I break these down into two broad categories. The first is macro, and what I mean by that are mechanisms that have been established in the international law system when you have disputes among states. So state versus state type disputes. That could be anything from establishing a border to violation of a treaty to trade issues. Now we've talked a lot about that already with regard to having the various different IGOs that have been established have built-in dispute resolution methodology. So, with the United Nations, we have the International Court of Justice as the primary judicial arm. Setting up a judicial branch within the UN system to resolve international disputes through that mechanism. Of course, the World Trade Organization has the dispute settlement system and the whole process there under the dispute settlement understanding with panels and consultations. We've talked about that. The old NAFTA, now the U.S.-Mexican trade agreement, also has a dispute resolution process which is similar to the WTO process involving consultations and panels. And again, this is built into the way the treaty establishes dispute resolution mechanisms within the treaty itself. The ICSID, which stands for International Center for Settlement of Investment Disputes, and we'll talk more about that a little bit later. That is a mechanism established through the World Bank for cases involving disputes among investors in a foreign country. And then finally, there are potential other court systems like within the European Union. So when we talk about dispute settlement macro being state versus state disputes, that has historically been, of course, as we've talked about over and over, the realm of international law, state versus state interaction. And then down below here we have micro. And what I'm referring to there is disputes involving either a state and a person, where a state has, through their action, done something that has harmed an individual person or a private company of some type. Now, historically, of course, international law didn't really deal with that. It was up to the person to petition their own government to try to help resolve that type of a dispute. And that, for example, might be expropriation, which we'll get to in a moment. And there are a lot of issues with that, and so the idea with IGOs and other international agreements is to establish mechanisms whereby if an individual, which may be a private person or a company, has been harmed, either through a taking or some other action, that they now have the ability and standing to bring their own form of dispute against a country. And then we have person versus person, and that is where you've got individuals that may be involved in perhaps international sales contract or some other type of business activity where they have a claim against a person from another country. And the question is, how do you resolve those kind of disputes? Do you do it in your own domestic court? Do you do it in the court of the country where the person resides that you have a dispute with? Or do you use some other mechanism such as arbitration? International Chamber of Commerce has various dispute resolution mechanisms for private individuals and companies, or through litigation in the court system. So, next slide over, I want you to remember this here. And historically, the general rule are disputes in international tribunals, such as the World Trade Organization, are typically reserved for states or IGOs only. and that is no individuals or private corporations or other multinational enterprises that are not states. And that has historically been the rule of international law, that disputes within the international law system, an individual did not have what we call standing. That's what I've written here. Standing is the term that refers to the legal ability to bring a case in a court or a tribunal, and that refers to a person who has an actual grievance of some type. And in international law, typically an individual person in most type of international tribunals do not have standing to bring a dispute against a foreign state. Typically, for example, the World Trade Organization system, only a state can bring a dispute through the system. Now that dispute may involve an individual or a private company of some type, but in order for them to bring a dispute to the WTO, it has to go through the government, and they would have to bring a dispute on behalf of the private person, because the private person or corporation does not have standing in the WTO to go through their system. And that's true with many of the IGOs, including the United Nations, of course, with the Court of Justice. Only a state, either a member state or in some cases a non-member state, can bring a case with the ICJ. So when we talk about one of the type of claims that is commonly involved, let me get to the right page here, page 12. When we talk about one of the common type of claims that an individual may have against a state is a claim for what is called expropriation. And this is a term that refers to when a government engages in activity that takes property of private persons by a governmental entity. So it's essentially a seizure or a nationalization, a taking, a condemnation. It goes by eminent domain. There are various different terms. And we have the same concept in the United States legal system. And this is essentially a scenario where you have an individual, perhaps a person that owns land, or a corporation that owns a factory or some other type of commercial property. And the government of a state seizes the property or takes the property such that the owner no longer has beneficial use of the property. We call that the right of eminent domain, down below here. So when we talk about expropriation on an international law level, it's analogous to the right of eminent domain in our United States legal system. Under the Fifth Amendment of our U.S. Constitution, if property is taken, the government must provide compensation. So that would include a seizure. So for example, maybe I had a farm and maybe a school district wants to build a new high school on my farmland, and I don't want to sell it. So the government has the ability through the right of eminent domain in what's called the condemnation process to essentially take my farmland even though I don't want to sell it. However, there has to be adequate compensation, has to be basically fair market value that is paid to me to compensate me for the taking of that property. And that actually is not an uncommon thing within our United States system. In that type of a circumstance, if my property is taken, I do have the ability to fight, primarily not over the condemnation itself, but over the value that is being offered to compensate for the taking of my property. And again, that's under the Fifth Amendment of the U.S. Constitution. It's called the Takings Clause. So we have an analogous right under international law. Now again, historically, in order for this to occur, you would have to, if you were the party that had the property taken, you would have to petition your government to take individual action. And so the idea is that leads to problems on an international level. And what this idea of expropriation is trying to provide mechanisms whereby, this is primarily going to be a corporation, whereby if a corporation has property seized by a foreign government, so maybe, for example, a corporation has established a factory, or they have land that is used for agricultural purposes, or manufacturing, or mining, or fishing, a fish processing plant, or ships, and those assets are seized by a foreign government. The idea is to put into place procedures whereby a private company or individual can bring a legal matter, a legal action against a foreign government that has taken their property. So kind of a scenario would be, let's say I have a fishing company, and we have fish processing plants all throughout the United States, up from Alaska all the way down to California. And then let's say we also have fish processing plants in Mexico and Costa Rica and other countries similar on the Pacific coast. And let's say Costa Rica comes in one day and seizes our fish processing plant in Punta Arenas, Costa Rica, and now we want to be compensated by the government of Costa Rica. So historically, again, for that to occur, we now have a dispute against the Costa Rican government. We would have to go to the U.S. government to try to get the Costa Rican government to respond to that. Now the problem, from a policy standpoint, and again, this post-World War II, the idea of trying to redevelop, post-World War II, reconstruct, also after the period of decolonialization, independent movement of many of the countries that were former colonies, the idea was to try to encourage foreign investment in lesser developed areas of the world. And the policy behind these ideas that we're going to talk about with expropriation was to help promote private investment in lesser developed areas without so much of the fear that an investor may have in having their property seized. And so the idea, first of all, of expropriation is under international law, the right of expropriation, meaning the right of a government to take property, is universally recognized, meaning a government of a country, that would include the United States, has the sovereign right built into its sovereignty to take and expropriate property if it's going to be used for a public purpose. So the next slide down below here is essentially the rule. Expropriation is legal and appropriate so long as it's done for, number one, a legitimate public purpose. And we have the same rule in domestic law. And this is the idea that if a government is going to seize property, it must be done not to benefit a private individual, but for a public purpose. That may be building a school or a roadway or other governmental buildings, basically a public purpose, not a private purpose. And the reason behind that is the idea that we don't want, essentially, government acting to benefit private individuals. So for example, perhaps there is a developer that wants a piece of land to build houses and condominiums and hotels, a private company, and they have friends in the government and they want to get that property from the current owner, but the current owner may not want to sell. So the developer who has friends in the government layers have them initiate a taking, an expropriation, to seize that property and then sell it to the developer for $1 or something. So that is a situation where you have a private purpose, but government activity. Now, under our Constitution and and case law, that is not typically going to be legal. The purpose of the taking must be for a purely public purpose. Although there have been some cases where the courts have ruled that if the taking is for a quasi-public purpose, like building out of a entertainment center area that includes both public and private space, that may be a proper condemnation. But for the most part, and we're just going to try to keep it simple for this class, the purpose of the expropriation must be done for a legitimate public purpose that does not discriminate against a particular class of foreign investors, and that is done for a purely public reason, not a private reason. Part two is, in order for the expropriation to be legal essentially under international law, and this is also true under domestic law in the U.S., the state must pay prompt, adequate, and effective compensation. That comes from an arbitration ruling in 1974. So next slide over. What do we mean by compensation? Well, this is where it gets to be and can lead to disputes. Oftentimes the taking itself is not really in dispute. You know, if the land is being taken to build a new school, that's clearly a public purpose. That's clearly within the realm of a government activity, which is legitimate. But the question is, if the payment that is being offered to the owner by the government, one has to be prompt and, you know, essentially immediate. Not, we'll pay you in 20 years from now, or we'll make payments to you over 200 years. That would essentially be an end run around compensation. And so the idea is there has to be compensation that's paid promptly. In addition, the compensation must be an adequate amount. So that is the dollar value in terms of the fair market value of the property or the assets that were seized. And that's where, again, you can get into a dispute. I'll just give you a real world example. Let's say it's a farm, but that farm, as a farm ground, will have a lower value than the value of that same property if it could be developed, let's say, into a subdivision for houses. And we have the same issue in U.S. law. So the farm ground, perhaps, as farm ground, may be worth $10,000 an acre. But if that property is developable into homes and apartments and whatnot, that value now is $100,000 an acre, 10-to-1 difference. So it's currently a farm, but it could be a development. So what is the proper measure of the value of that ground? And that's a lot of times where these disputes end up in some form of litigation or other mechanism because there's an argument over how to value the land or other assets that are being taken. So essentially the idea under U.S. law, and this is mirrored in international law, is there has to be the fair market value based on the highest and best use of the land. So if that land could be developed into apartments and houses, that would be the highest value, and that is what would need to be paid. And then finally, the compensation has to be effective, and what's meant by that is, a scenario perhaps where land is taken by a government, expropriated, and they do offer up compensation right away, fair market value. However, as part, let's say, of the compensation package, the government stipulates that the money that is paid to the company cannot be removed from the banking system of that country for a period of 5 years, or perhaps one of the stipulations is the compensation must be reinvested in the country by either purchasing another property or factory or whatever, or perhaps it's paid in a local currency that is not effectively able to be converted to other currencies for whatever reason. Maybe there's a capitalization requirement where the country may require that the currency stay within the country, or maybe they devalue the currency after they pay it so that the value at the time it was paid was adequate, but essentially by the time you can exchange it to dollars or euros or gold or whatever, it's no longer effective. So this is where we see within expropriation these issues of compensation, how does that determine, and potential disputes that may arise out of that. Now, oftentimes arguments are made, especially in lesser developed areas that were former colonies. One of the arguments of the government when property is expropriated is that the value should also take into account full market value, but also factors should be taken into account about the profits that have been extracted from the property during colonial domination. So for example, perhaps it's a banana plantation in Costa Rica that's being taken, and the corporation has held that banana plantation as a colonial endeavor for decades, if not hundreds of years. And so the argument that is made by the government, let's say of Costa Rica, when they expropriate the property, is that you need to take into account all the profits that have been made from this property that was essentially taken at the beginning when you were arguing about whether or not compensation should be current fair market value or current fair market value discounted because the corporation has been receiving all of these gains over the years. And so that's another type of argument that's made when we talk about valuation. There's another type of expropriation, it's on page 14. I want you to know a term. And this is the term creeping expropriation. Kind of a weird term. Creeping expropriation. This refers to, well, let me contrast that with just sort of your standard everyday type of expropriation. Traditional expropriation is a government entity comes in and literally takes a building and land and kicks the people out, and it's now used by the government. It's done right there on the spot. Creeping expropriation refers to another way that property essentially can be taken, but not necessarily through direct seizure. This is a series of administrative actions by a governmental entity or those acting on behalf of a governmental entity, whereby over a period of time, there are various actions that eventually, when you pile them onto each other, have the effect of essentially taking the property such that it's no longer really having any value or cannot really be used by the owner for anything that is economically beneficial. We have a similar theory of law in United States law, which is called an administrative taking. And so just to kind of give you an idea, let's say I've got farmland that I currently use to grow grass seed, like we do here in the valley. And so administrative agencies may impose various different regulations that limit the ability to type of seeds I can plant, what type of chemicals can be applied, or completely prohibit use of chemicals, or the fields can only be accessed during certain parts of the week or year, or something of that nature. So eventually all of these rules stack up on top of each other to the point where at some point you can no longer really use your land. Even though you own it, there are so many administrative regulations that have been applied that they no longer amount to true ownership of the land. Or this could also be a situation like if it's a factory, perhaps a governmental entity has inspectors going out to the factory every single hour. They park military equipment around a factory so you can't access it. They put up barriers to the dock so ship fishing vessels cannot dock. So they haven't actually taken the processing plant, but through various actions, either through administrative rules or actions by a governmental entity, essentially you can no longer use your property. And so at that point you would make the argument, well, even though I still own the property, essentially through governmental action, my beneficial use of the property has been deprived to the point where it actually is the same as if you seized the property itself. And therefore, you should be entitled to compensation as a form of expropriation or condemnation under U.S. law. This would be something like, there have actually been arguments made here in the United States on building moratoriums. There's a series of cases out of the Lake Tahoe Basin area where they talk about putting a moratorium, in other words, prohibition on any more building. And so the argument there is you own the land, but you can no longer build on it. You should therefore be compensated for the lost value due to those regulations. So that's another area where you see a lot of dispute, or again, you're not really fighting the condemnation, but it's the valuation. All right, so let's say you are a private investor and you're a company that wants to make an investment in a country, and you're concerned about these various different type of risks that you face when you're making an investment. You're going to build a factory or build an airport or whatever, and so a company's going to put in millions and millions, if not billions of dollars as an investment. So how, as a company, a private company, what steps can you take to try to protect yourself against the possibility of expropriation or other type of risks that you may face in making an investment in a foreign country? So this is where, within the framework of IGOs and NGOs and then private industry, private enterprises, there have been the development of insurance programs that will provide some ability of private investment companies to be compensated through an insurance type of a policy rather than having to pursue a taking claim against a government. So the one that we want to look at first of all here is what's called political risk insurance. But these are various different type of insurances. International property and casualty insurance, that would be for events involving a fire or a natural catastrophe such as an earthquake. You also want to look at insurance for your employees overseas, and then political risk insurance. So let's talk about the bottom one because that's the one I want to focus on. So we talk about political risk insurance. It's on page 15. I want you to be aware of two programs that have essentially the same goal, but one is established through the United States federal government, and the other is through, it's a branch of the World Bank called MIGA, Multilateral Investment Guarantee Agency. So both of these are very similar. Both of these are programs that are designed to provide what amounts to insurance to pay for the loss of an investment due to expropriation or other political risk. So the U.S. Overseas Private Investment Corporation, or abbreviated OPIC, is a program run by the United States government and allows for United States-based businesses to apply for an insurance policy when they're making an investment in a foreign area, in a foreign country, and that will provide insurance in the event of an expropriation or other political risk activity, which we'll get more to in a minute. That is limited to United States-based companies. The other program that is similar, and they offer very similar insurance coverages, is MIGA, and that is the Multilateral Investment Guarantee Agency. And this is a program, again, through the World, it's a derivative of the World Bank, that will provide insurance coverage for World Bank member country businesses, and to provide coverage in the event of expropriation or other type of political risk. So, next page over, actually 2 pages over. So these are the typical risks that are covered by both an OPIC or a MIGA type of a policy. So first of all, expropriation or confiscation. So this would be an insurance policy that would pay the company that has made the investment and had their assets seized through expropriation directly. So here's the idea. If I'm a company, let's say again I'm going to build an airport in another country, I'm going to make a very large investment of capital, and we're concerned that that airport and all the infrastructure, the terminal and the hangars and the fueling and all that may be seized by the government at some point. And so we have a policy of insurance that covers expropriation. Now, why is this important to me? So let's say I'm a US-based company, just for the scenario. So now if the airport or part of the airport is seized as an expropriated property, as the US company, rather than having to go battle it out with the government that seized that asset, I can now go to OPIC or MIGA and file a claim, just like I would if my house caught on fire. I'd file a claim with State Farm Insurance. And now, I could stay in the US, I don't have to go file a claim of some type in a foreign court, and I'm now going to be compensated by a US company or by MIGA here in the United States. Now that's very important because it's a streamlined process. Number one, I can file domestically if I'm not paid. I could file a court case in the United States courts. I'm paid in the currency, US dollars or euros, whatever the case may be. So I don't have to worry about converting from a foreign currency through the exchange process. If I'm not paid adequate compensation, I have the ability to fight that here through either a court or other type of process without, at the domestic level. So the point being is, if I get into that situation where our assets are seized, my fight now is not necessarily against the foreign government, it's against the insurance company. And then the insurance company, OPIC or MIGA, when they pay out on that claim, they take over the claim against the country that seized the property for what's called subordination or reimbursement. So essentially the idea is, the policy behind it is, again, to help promote international development in lesser developed areas, to help promote and provide stability and also assurance for investors that they will have the ability to be repaid in the event of an expropriation type policy. The second type of policy is currency inconvertibility or transfer risk. This refers to risk involved, again, if there's an expropriation and you're paid in the local currency and the government that paid you either devalues the currency overnight or they place restrictions on the expatriation or removing the currency from the economy of that government that paid you, or they may put limits on the ability to convert the total amount of the currency all at one time so that it doesn't devalue the internal currency. So that's a form of inconvertibility, again, which if I'm a company, rather than having to file some kind of a claim against a foreign country that has devalued their currency, I can make the argument that I'm going to be paid for my insurance policy in US dollars or euros or whatever the monetary denomination is, and I don't have to make that argument in a foreign court. And the final area is risks involving political violence. That would be things like insurrection or other types of political violence, which, obviously that can be a risk. We have similar type of coverage available in the US for political violence, that kind of thing. So MIGA, created in the mid-1980s, began operating in 1987, which is through the World Bank. And again, it operates under the idea that it allows for promotion of investments for international investments and investors. As part of MIGA, page 18, as part of this idea, the World Bank also established, well, this is prior to MIGA, but the World Bank also established the ICSID. It's on page 18. This is the International Center for Settlement of Investment Disputes. And this is a program, and again, I want to go back to the idea an individual party has been harmed, maybe through expropriation, had their assets taken, the ability for them to file a claim directly against a foreign government. Historically, they weren't able to do that. Well, in order to promote investment again, the idea was to establish a form of an arbitration system in international law whereby members of the World Bank community, countries that are part of the World Bank, and agree to be part of this program ahead of time, which is a stipulation for them to be able to get money, essentially. They also agree that if there is an expropriation or other type of claim whereby that amounts to expropriation, the company that has made the investment and had their property taken now has the ability to file a case directly through the ICSID. So it is a form of, next page over, the purpose was to encourage private investment in underdeveloped countries by providing a reliable mechanism for resolving disputes between an investor and the country of investment. And about half the countries of the world, are 90-ish if I remember, signatories to the Washington Convention, which is the treaty that established it. So here's the basic idea. This sets up the ability for an individual to form an ICSID arbitration tribunal. Now, arbitration is a very common method of resolving disputes internationally and also domestically. We see a lot of it here in the US. Arbitration is where you have a neutral person who acts like a judge, or it may be a panel of 3 or 5 or 7 or 9, an odd number, so they can have a majority vote. And the panel will then act as a judge to resolve a dispute, and that way you don't have to go through a court system type situation, or you don't have to go through political mechanisms. It can be done as a matter of an arbitrated panel. And they will hold a hearing just like a trial. It may be live or it may be done on paper. And essentially, this gives the private company that has had their property taken the ability to file a claim of their own, where historically they didn't have that. So it is a form of an arbitration. Next page over. Where'd my highlighter go? So the way in order to be able to file an arbitration with ICSID, both the investment company and the host state, that is where the property is located that's been taken, must consent to the jurisdiction of the ICSID for cases of that type. And that's done typically ahead of time. So member countries can agree ahead of time, this is before disputes ever occur, that they will be under the jurisdiction and subject to an arbitration in the event of expropriation involving companies or people of their respective states. So this is done ahead of time. Down below here, as part of being involved in an ICSID arbitration, the parties agree to exclude all other remedies. In other words, they agree that the arbitration decision will be the sole mechanism to resolve the dispute, and unilateral withdrawal is ineffective, meaning the state that has seized the property but has previously agreed to an arbitration jurisdiction cannot just on their own say, we withdraw, we're not going to follow it. They're required to maintain and comply with the decisions. Next page over. The ICSID awards are binding, and contracting states agree to comply with them. And in the event that they're in non-compliance, an action can be taken through the ICSID, including sanctions, the inability of a country to receive funds from the World Bank, or other type of remedies. Now, I'm not going to hold you to all the nitty-gritty parts of the ICSID. The main component I want you to be aware of is, again, back to this idea of state versus person claims. And this is where we have this growth and evolution of international law that now allows for mechanisms such as the ICSID for individuals to take direct action where historically they didn't really have that ability. So you're a foreign investor now. When you go in to negotiate the contract with a foreign government, you might include a provision that requires arbitration in the event of a dispute. You would also require insurance under MIGA to cover claims arising out of political violence or currency incontrovertibility, or those kind of claims as part of your contract. So we also see arbitration utilized in the private sector very commonly, and this is a component of international contracts for sale, for example. So it's very common to include a paragraph that requires, in the event of a dispute, you will have an international arbitration or mediation. Mediation is where you have a neutral third party that will negotiate the case between the parties to try to resolve a dispute. So there's a couple of terms I want you to be aware of. You've got to find the slide here. Okay, page 8. So now we're talking about a contract. Contract provisions, so perhaps it's a contract between a French company and a U.S. company, and for sale of grapes or wine or whatever it may be. So as part of the contract, when I am writing up a contract for international sales, there are various different provisions in the contract that we want to negotiate and discuss, and have language in the contract involving, first of all, choice of law, conflict of law rules. So this is a paragraph within a contract. This may also include a treaty or other type of agreement whereby it is written into the contract and the parties agree as part of becoming part of the contract what law will apply in the event of a dispute. It's called a choice of law clause. And we have the same thing domestically in the U.S., where maybe you have a transaction crossing state lines, and the parties will agree in the contract that in the event of a dispute, the law of the state of Oregon, or law of Idaho, or wherever will apply. Well, this would be the same type of thing. In the event of a dispute, what law will apply as between a French company and a U.S. company, and they may decide, okay, United States law will apply to how the contract is formed and interpreted and enforced, and they will write that into the contract itself, that the law of the United States, either federal law or the law of perhaps New York State, will apply in the event of any dispute arising out of the contract. Or it could be the other way around. They'll apply the law of French contract law, and in the event of a dispute, that law will be applied. Or if they cannot agree, there are United Nations conventions that basically are a blend of civil and common law principles. So the point I'm making is it's very important in an international sales contract to try to reduce disputes to include a choice of law clause. Now, of course, that's going to be negotiable. If you are negotiating an international contract, one of the points you're going to negotiate is what law will apply. And obviously, you're going to want the law of your home state to apply. If you're the French company, you're going to want French law to apply because there's costs involved for both parties. So this is a point that would have to be negotiated. Similar to that, next page over, we have choice of law, which I've talked about, and then we have choice of forum. So this is a paragraph in a contract. Again, if there is a dispute, where will that dispute be resolved? What forum? Will it be in a domestic court, like the federal district court in the United States? Or will it be in a French court in Paris? Or will it be done through an arbitration program that's done privately outside of the official court system, but then can be registered with the courts as a judgment? So what will be the forum that will be the place where the dispute will be resolved in the event you have a fight? So this is very common, and again, this is a negotiable point as well, but can also lead to disputes, because if you're not sure if I file where to file, that, and whether or not there's jurisdiction, that could be a problem. As part of this choice of forum clause, both parties will typically also agree to the jurisdiction of the court. In other words, the French company will agree that if there is a dispute, they will be subject to the authority of a United States court, or vice versa. And that is essentially consent to jurisdiction. That is the authority of a domestic court that may not otherwise have authority over that French company. So these clauses, you see them both in private contracts and public contracts, and you're setting up ahead of time how you're going to resolve those international disputes. Now, we've talked about arbitration, which is a very common method of dispute resolution, both publicly and privately. So the United Nations has established rules for international arbitration to help promote the use of arbitration as a dispute resolution mechanism, both, again, privately and publicly. And these are rules that can be adopted and incorporated into a treaty or a contract. And they have actual model rules that you can literally cut and paste on their website and put into your contract. multiple different languages. And so this gives a middle ground, if you will, for parties to a contract if they don't want to adopt US law or French law or other type of arbitration rules. They can adopt the UN rules on arbitration that will apply in the event of a dispute. And then those rules are very detailed. They provide things like time frames for submission of documents, what form documents and evidence have to be in, how to constitute an arbitration panel, cost allocations, like who pays for it, and that kind of thing. In addition, there are private companies. The American Arbitration Association, for example, is a private company that provides both domestic and international dispute resolution programs, which may include an arbitration or mediators, and they have a panel of experts that can serve as arbitrators or mediators. Or they also have the ability to put together multi-person panels to help resolve both domestic and international disputes involving contracts and other claims. Very, very common. I actually, when I write contracts, oftentimes I will include in a contract, maybe it's a real estate deal or whatever, that if there's a dispute, it will be resolved through an arbitration under AAA rules, or American Arbitration Association rules. They have a chapter in Portland in a building where you can go and actually hold the arbitration. And there are a number of these. There used to be, this is out of business now, but the electronic courthouse, there are others that function for this now, but this is a private company that provided online dispute resolution services. And it can be done literally by email, or nowadays with Zoom, or other type of electronic remote meetings. And this is sort of the trend. Primarily where you're going to see this is in a private transaction, like a sales contract. And the beneficial part about this electronic dispute resolution is it can be very quick and efficient. You know, especially if you have a situation, you know, maybe I'm buying a load of fresh seafood from you and we get into a dispute about payment. Well, that seafood's going to go bad. We got to get it figured out quickly. Other methods, going through the court and everything else, is very time consuming and costly. And so we can write into our contract that we will initiate an electronic form of dispute resolution in the event of certain types of disputes, maybe over delivery methods or payment methods, packaging, whatever. And that can be done almost instantaneously through a Zoom or other remote type of meeting. And again, the point of making, there are lots of these. The point of making is this is the trend, again, with the rise of IGOs, in providing these different mechanisms to resolve disputes through rule of law versus political mechanism, political means. Next page over. More or other private type international dispute mechanisms. The International Chamber of Commerce, which is a NGO, and they have multiple different programs involving international business, some of which we'll talk more about in a couple class sessions involving transportation terms, shipping terms. But they also provide dispute resolution mechanisms for primarily private individuals and corporations that are doing international trade. So they have the International Court of Arbitration, which is part of the International Chamber of Commerce system. And that is it's a form of an arbitration panel that can be used to resolve disputes in contract law or tort law. Their arbitrations are typically held in Paris or New York City or wherever the parties may agree. And again, this is going to be part of a contract that would be in the event of a dispute, we will adopt the rules of the International Court of Arbitration, and the parties agree to comply with the outcome. and the judgment and decision of the International Court of Arbitration would then be registered in a local court for enforcement. And they provide, I mean, just kind of nuts and bolts. They provide everything from notifying the parties, setting up timeframes and schedules, providing arbitrators to make a decision, those kind of things. There's also, the International Chamber of Commerce has dispute boards involving credit disputes, for example, letters of credit, which we'll talk about next week, and other financial disputes involving international sales. So these are just a number of examples of ways that dispute resolution internationally has really developed with the trend towards setting up these systems that provide structure and an ongoing organization that has headquarters and a forum and everything, so you know where to go in the event of a dispute, rather than trying to figure out who has jurisdiction, what law will apply. How can you structure things ahead of time to, if you do get into a dispute, protect yourself. Okay, where is that page? I forgot to talk about this page, page 18. Sorry, I'm kind of jumping around a little bit. I forgot to talk about this page. So again, what are some mechanisms that you, if you're page 18, an owner, or you're going to have a contract or do an investment, these are some other types of insurance that are available. Cargo insurance, which is insurance that will cover in the event of damage or destruction of cargo that is being shipped. And that will depend on the mode of transportation. It may be maritime, in other words on a ship, or a container that's placed on a ship, which is really common. It could be aircraft, or it could be through train, or multimodal, which is a combination of all of the above. And so that's insurance. That is a typical requirement of most international sales contracts, that either the buyer or the seller will need to provide cargo insurance in the event of damage or destruction. That's a negotiable point between the buyer and the seller. We'll talk more about that on who actually pays for the insurance when we get to Incoterms next week, shipping terms. There's also insurance that will pay in the event of kidnap, ransom, and or extortion. This is primarily going to be involved if you have employees or other affiliates of your business. Emergency evacuation insurance in the event of either political or environmental problems, such as a volcano or political instability. You know, you've got to evac your people out. That's expensive. It can range for aircraft and helicopters and everything else. And again, there's insurance that you can provide for that. You see that a lot in mining and oil and other type agricultural, where you've got, you know, your workers around that you may need to evac out, or in the event of an injury, paying for helicopter evac. Then sabotage, terrorism insurance, repatriation for an injured worker, other type of insurances. And again, the idea is how can you, as the manager of the business or CEO or whatever, how can you make these plans ahead of time? So if you do get into a dispute, you've got a mechanism to be paid either through insurance for expropriation or have other type of insurance available, so that your claim now is with the insurance company and not with the country. That's the point. It provides that middle ground, which gives you more adequate assurances that you will be compensated or covered in the event of expropriation or other loss of that nature. So it's substituting the insurance company for the foreign government, and then the foreign government and the insurance company basically fight it out. And the idea being, if you're MIGA through the World Bank, you got a lot more leverage over the country than an individual company does. covered that section, so.